Hey everyone, it is Rob Ryder, and today we will be talking about the National Archives and Records Administration Office and the Office of the Federal Register, which falls under the same office. An item called slip laws, which are really um, public acts that haven't been bound together yet in the statute at large. It's just a particular act. And then positive law, which are titles of the United States Code that have been enacted as a statute in its entirety. So instead of just one little law, like a slip law, it's a bunch of laws all put together in a title. And now that is made a statute. A little bit about the Electoral College and, as a matter of fact, the Continental Congress. Because they all, all the stuff at some level all fits together, and it's like, well, ain't that something? What it kind of looks like. Because for instance, in your state, for elections, it's the Secretary of State that handles things for elections. But the Electoral College, which is electing the president, is handled by the National Archives. It's not handled by the Secretary of State. Right? Because that Secretary of State, I guess we could say, well, that's over in the foreign relations area. So who's acting as the Secretary of State for the President? And it turns out it's the National Archives. And so if you get things, these slip laws and positive laws, under their seal, it carries a tremendous amount of weight. It's foolproof evidence. Self-authenticating, it doesn't take anything else for it to say it is what it is. It just is because it was blessed off by the National Archives administrator. So my email address is courtofrecord@aol.com, and it is April 30th, 2015, which means, hey, the rent's due. Please help if you're able. The PayPal account is ashleyrytlewski@gmail.com, ASHLEYRYTLEWSKI@gmail.com, or snail mail to myself. And why don't you just pause right now and write that down for later? I appreciate it. Probably the easiest place to start, because this is taking pieces from all over different things I've looked at in the last couple of weeks, working towards the creation of a remedy, which is in Title 28, the Judicial Code, which, as it turns out, is positive law. But it's not the right place to start. So we got to, let's go back to number one, right? Always start at the beginning. It's funny how that works out. Yeah, but before we can do that, just because I think you should know this, you may want to write this down too. So the text of these individual pamphlet slip laws, they come from the Superintendent of Documents, U.S. Government Printing Office, Washington, D.C. 20402, phone number 202-512-2470. However, Bobby in Arizona has tried to call that number and nothing happens. And so I did a search on the phone number, and it's actually supposed to be going to a place called the Congressional Document Orders. And what are congressional documents? Well, those would be acts of Congress. Yeah. So you want to order an act of Congress, basically. And it gives those two different numbers, possibilities there. And as of last night, according to Bob, he wasn't able to get through. Yeah, we'll see what happens next. But there it is. Forget the phone number, right? You're trying to get a hold of congressional document orders because you want to order from the Superintendent of Documents, U.S. Government Printing Office, individual pamphlet form slip law, because it says I can. Right? That's why we do it, because it says I can. All right, so you all know there's a bunch of titles to the U.S. Code, Title 1 through like Title 50, I think it is. Well, the very first one, and not starting at the very beginning, which we could, but due to time, we're not going to. Just the things that we can really use right away. So, in 1 U.S.C., subsection 112, it says statutes at large. The Archivist of the United States shall cause to be compiled, edited, indexed, and published. So who's doing this? Right? It's somebody called the Archivist of the United States, who's going to cause to be compiled, edited, indexed, and published the United States statutes at large, which shall contain, shall contain all the laws and concurrent resolutions enacted during each regular session of Congress. Well, so there you go. Shall contain all the laws and concurrent resolutions enacted during each regular session of Congress. So a statute at large is a compilation of all the slip laws, the individual acts put together and put into a book. And that comes up in 113, section 113, but they did it this way, so we're going to talk about the statutes at large first. Okay, plus all proclamations by the President in numbered series issued since the date of the adjournment of the regular session of Congress next proceeding. Now, somebody unravel that sentence and understand that right now we're at, like, if you went to the Federal Register and looked for presidential proclamations, during Clinton's time we were at 7,000. During Truman's time we were at like 3,000 proclamations by the President. And it just sounds to me like in this that, you know, somehow the numbers were supposed to, the series is supposed to change since the date of adjournment of the regular session of Congress. Because I don't believe the Congress that we see in there is actually the regular session. They're in a special session. They've never actually shut the session down or something like that. But that isn't why we're here, and I'm not going to get too bogged down on that. I'm just saying there's something about that, right? For those who like to do puzzles, figure that puzzle out. And also, any amendments to the Constitution of the United States proposed or ratified pursuant to Article 4, since the date together certified with the Archivist of the United States issued in compliance a certificate of the Archivist, yada, yada, yada. So whenever official notice received by National Archives or Administration, then an amendment proposed to the Constitution of the United States has been adopted in accordance with provisions of the Constitution, the Archivist of the United States shall forthwith cause the amendment to be published with his certificate specifying the state by which is saying the same has been adopted, yada, yada, yada. So if you want to know, basically, if you want to know if any amendment has been ratified, you would contact the Archivist. And there's a lot of questions on if a lot of these amendments have ever been properly ratified. And when you read about the Archivist, you know, I don't know if we'll get to it eventually, but I don't know that's right in this part. But he's the one who can tell you if it's been done. In the event of any extra session of Congress, the Archivist of the United States shall cause all laws, concurrent resolutions enacted during the extra session to be consolidated with and published as part of the contents of the volume of the next regular session. The United States statutes at large shall be legal evidence of laws, concurrent resolutions, treaties, international agreements, other treaties, proclamations, in all courts of the United States, the several states and territories and insular possessions of the United States. Okay, so if you had a statute at large and you had it under the seal of the Archivist, it would be basically foolproof evidence, self-authenticated evidence. It needs nothing else to say it is what it is. It is legal evidence. It's much better than prima facie evidence, which can be rebutted, and that's, what they can do. Okay, and it talks about treaties and so forth. This is all in 112, and okay, enough on that. But I want to get to the one I'm planning on using, which is 113, where it says Little Brown's edition of laws and treaties, slip laws, yada, yada, yada. The edition of the laws and treaties of the United States published by Little Brown, and the publication in slip or pamphlet form of the laws of the United States issued under the authority of the Archivist of the United States. So they just need to be issued under the authority of the Archivist of the United States. And the treaties and other international acts issued under the authority of the Secretary of State which I really think is the same person, just that's his other hat, Archivist in one matter, Secretary of State in the other, of the Continental Congress that elects the electors, and it's the Congress that established the Northwest Ordinance. Right? And that Congress didn't have two houses, only had one house, delegates from the state, almost like the electors, or the people that elected the electors. So, but, that'll all work itself out. Right now I want to be able to use their law, and this says so in 1 U.S.C. 113 it says that the additional laws and treaties of the United States published in Little and Brown, which is basically the statutes at large, if I'm not mistaken, and the publications in slip, a single form of the law, so a single act of Congress of the United States issued under the authority, because those are what the laws of the United States are. They're the acts of Congress that have been enacted. Under the authority of the Archivist of the United States shall be competent evidence of the several public and private acts of Congress and of the treaties, international agreements, other than treaties, blah, 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 in all courts of law and equity and of maritime jurisdiction, and in all the tribunals and public offices of the United States and of the several states without any further proof or authentication thereof. So if I get a slip law, and I'm sure this is the same with the statute at large, but I'm just talking about using one particular law, act of Congress, such as the False Statements Accountability Act of 1996. Well, that law, if it's issued under the authority of the Archivist of the United States, in all courts of law, equity and maritime jurisdiction, and in all tribunals and public offices of the United States and the several states, so now this all the state offices, without any further proof of authentication thereof. That's a powerful piece of paper. I'm going to have to get me one of them. And then sealing of instruments. In all cases where seal is necessary by law to any commission, process, or other instrument provided for by the laws of Congress, it shall be lawful to affix the proper seal by making an impression therein directly on the paper to which such seal is necessary. This shall be as valid as if made on wax or other adhesive substance. So if it needs to have a seal, them just impressing it is good enough. So they say. Okay. 201. Publications. Publishing in slip and pamphlet form or in the statutes at large. Publication in slip, pamphlet form, or the statutes at large of any of the volumes or any of the volumes. Publications enumerated in 202-203 of this title shall, in event of enactment, be dispensed with whenever the Committee of the Judiciary of the House of Representatives so directs the Archivist of the United States. So they're going to tell the Archivist of the United States when to publish the law because it's been enacted. Director of the Government Publishing Office shall print such numbers as are necessary for depository library distribution and for sale. Because there's depository libraries all over the United States, and they should have copies of these laws too, and it's another place you're supposed to be able to go to get a copy of a slip law, to the depository libraries. Now, I think I understand what this lady told Bob, because he was talking to a librarian at the state library, and they said if you came down and made a copy of it, they would take you over to a notary and have it notarized. Okay, so they're not going to give you their copy, but they're going to certify that they have a copy and, get it under the notary. So I can see where that would work. Because we shouldn't have to go to Washington, D.C. to get this stuff done. That's my point. If I need a hard paper copy, I ought to be able to go to the library, to the statutes at large then, have them printed out, and have them put a seal on it and say this came out of the current statutes at large. Yeah, we'll find out. Okay. So there's a whole bunch of this stuff, and I don't have time to go through them all. But here's one I wanted to get to next. 204. In all courts, tribunals, and public offices of the United States, at home or abroad, of the District of Columbia, and of each state, territory, or insular possession of the United States. I don't know what else there is within the continental United States that we could talk about as far as a jurisdiction. I think that pretty much covers them all. In all of these, right? The United States Code. So I don't care if you're in a state court, local court, county court, whatever it is, the United States Code, according to this, the matter set forth in the edition of the Code of Law of the United States, current at this and any time, shall, together with the then current supplement, if any, establish prima facie the laws of the United States, general and permanent in their nature, in force on the day preceding the commencement of the session following the last session of the legislation, which is included, provided, however, that whenever titles of such code, so like this is Title I of the U.S. Code, shall have been enacted into positive law, which this one has, the text thereof shall be legal evidence of the laws therein contained in all courts of the United States, the several states, the territories, insular possession of the United States. Well, there you go. So if you were to cite properly, or provide the text, because you can download all this stuff, and it comes from a section, a title that has been made positive law, the text itself is legal evidence. I don't need to have it under seal. I just need to have something that is been enacted in a positive law, print it out and bring it in. And tell them. But it'd still be better to have a seal on it, as far as I'm concerned. If I get a seal, I get a seal. But anyway, so here's some of them that have been put into positive law, like 1, 3, 4, 5, but no 8. So, right, so 8 is one of them that I need, because 8 is immigration. So it goes through a whole list of them. So any of these titles, that if you were using something out of here, the text itself is considered legal evidence, which is better than prima facie evidence. But if it's not one that has been made into a positive law, then it's really just put together for editorial purposes. And so like this didn't have 18, right? Title 18 isn't listed. 9, 14, 17. Oh, don't tell me 18's in there. I guess it is. Make me a liar. I thought on another page I saw that it wasn't on there. I'm a little bit confused now. But okay, so it is. Good deal. We just need to make sure that we're providing it properly to them. Now this I found interesting. Title 26, Internal Revenue Code. The Internal Revenue Code in 1954 was enacted in the form of a separate code by an act in 1954, obviously. Provided that the Internal Revenue Code, enacted August 16, 1954, as heretofore, hereby, or hereafter amended, may be cited as the Internal Revenue Code in 1986. Right? So if you were going to cite anything to do with Title 26, Internal Revenue Code, the proper way to cite it is the Internal Revenue Code of 1986. And, do you need to put the parentheses marks? I don't know. I'm just saying that's what it says to do. You don't call it Title 26. The sections of Title 26, however, of the United States Code are identical to the sections of the Internal Revenue Code. So, Title 26 apparently isn't in here. Nope. But what has been made into positive law, or at least enacted, may now be cited as the Internal Revenue Code of 1986. So if you're trying to use Title 26 to your advantage, because I know people have tried that before, um, right idea, the sections are correct, but you cited the wrong document. And whether you need to get the sections from the archivist or not, well, these are things to be found out. Okay, that's enough on that one. Now, let's see where we are. Yeah, just a second. Okay, so back to 1 U.S.C. 113, which says Little and Brown's edition of laws and treaties, slip laws, treaties, other international acts, series, admissibility and evidence. So the edition of the laws and treaties of the United States published by Little and Brown, and the publications in slip or pamphlet form of the laws of the United States issued under the authority of the Archivist of the United States shall be competent evidence in all courts of law and equity and of maritime jurisdiction and in all tribunals and public offices of the United States. That would be like your congressman's office or Social Security Administration or, all sorts of places. The post office. And of the several states, well, they got the same thing. All their offices, it's the law, without any further proof or authentication thereof. So, first of all, who could we take it to? But how do we get a copy? What do they look like? So let's go take a look at that for a second. And we're going to do that by going here. So this is the National Archives site. And if you went up here to the search box and put in SLIP, S-L-I-P, space law, L-A-W, and did a search, the first hit you should get is Federal Register Publication System, Public Laws. Let's look at that one. And it's publishing public laws. Well, here we go. We prepare each law for publication as a slip law, also an individual pamphlet print. We then compile, index, and publish the laws in the United States Statutes at Large, a permanent bound volume of the laws of each session of Congress. Simple enough. Statutes at Large is just all the slip laws put together in a book. But they're still slip laws. The slip law is an official publication of the laws and is admissible as legal evidence. 1 U.S.C. 113, right? We're getting this right off the National Archives site now. The OFR, Office of Federal Regulations, Register, assigns the permanent law number and legal statutory citation of, the legal statutory citation, we'd have to know what that is, and the public law number, permanent law number as far as that goes, of each law, and prepares marginal notes, citations, and the legislative history, brief description of the actions taken, all sorts of stuff. However, slip laws can be obtained as electronic documents free of charge on a GPO's digital maintained by the U.S. Government Printing Office. Now, on the same page, it talks about statutes at large, right? Section 112, two sections we talked about. And if you want an electronic document, you go to this one. The problem is statutes at large don't go back that far. And I don't really know how far slip laws go back, but if you click right there and go to electronic documents, you end up on this page of the U.S. Government Publishing House. But I do believe there's another way to do it to find the information you're looking for, because I did get a copy of a slip law that we'll look at shortly. I'm just showing you what their website says to do. Right? And what it says. But it says the slip law is an official publication of the law and is admissible as legal evidence under subsection 113. So if you're going to call the National Archives, or you're going to do whatever you need to do to get a copy of a law, you want to tell them, I want it to be in conformance with section 1 U.S.C. 1333. as legal evidence in all courts of law and equity and of maritime jurisdiction. I mean, I would print this thing out and carry it in your wallet, right? When you give it to me, I want it to be of this quality. Archivist. Okay, let's see here. So, okay, so that's a slip law. Then the slip laws are put in the statutes at large, and for the statutes at large, they're editorially bound into titles of the U.S. Code. And until they're made into positive law, codified as positive law, in which case the whole title is going to become a statute, then in the editorial ones that aren't positive law, then each of those in there is a statute. Right? One's going to make the whole book a statute. The other one is a bunch of individual ones just bound together by subject matter, basically, or whatever that would be. But this positive law codification, it comes off of they have an office that does this. The Office of Law Revisions Counsel, United States Code. And because I can't read that. Positive law codification by the Office of Law Revision Counsel is the process of preparing and enacting codification bill to restate existing law as a positive law title of the United States Code. The restatement conforms to the policy, intent, and purposes of Congress and the original enactments, but the organizational structure of the law is improved, obsolete provisions are eliminated, makes it better. The term positive law has long established meaning in legal philosophy, but has a narrow meaning when it comes to titles of the code. And you have to click more to go read more about it. The code is divided into titles according to subject matter. Some of them are called positive law titles, the rest are non-positive law titles. A positive law title of the code is itself a federal statute. A non-positive law title of the code is an editorial compilation of federal statutes, so it's a book of singular federal statutes. For example, Title 10, Armed Forces, is a positive law title. So is Title 1. It's itself been enacted. We'll look at that one in a minute, but like here's Title 1, right, where it says on the front page of Title 1, where did it say? Positive law citation. This title has been made positive law by Section 1 of an Act, July 30th, 1947, of Act, Section 1 of Act, July 30, 19... Is that the name of the Act? July 30, 1947? That's interesting. I have to get a copy of that Act. Chapter 388, which is 61 Stat 633, which provided in part that Title I United States Code entitled General Provisions is codified and enacted into positive law and may be cited as 1 U.S.C. comma, subsection, number, period. I think you got to do it just like that, or they would say, well, you didn't do it right. Every tittle of the law has got to be perfect. Now, on a lot of these, when you download them off the government's website, it has this little bird up here, and it says authenticated. I don't know if you can read that. Let's get it bigger. Authenticated U.S. government information. Remember, I said you could get a slip law for free. Let me go back here real quick. Electronic documents free of charge, right? So the slip laws, which are admissible as legal evidence, you could get for free electronically. And I believe that that's what this is, because this says document certified by superintendent of documents, which is the one that's supposed to be doing it for us. And if you click on it, it gives you a whole certificate page of stuff that, I don't understand that well. I'm just going to say, okay, I got it, but I don't believe I can put it in paper form and give it to somebody. Here's all the stuff about a certificate for it, right? That's all embedded somehow into that eagle. But I should be able to send it to somebody by email. And email is really the same as mail, and it would, they track this stuff. It's like, well, yeah, they would know that they got it and that I sent them an authenticated copy. And so maybe that's how you can use the law, by email. So that's what I'm going to try. I'm just going to try email, and when I put my thing together, it will be just emailed first to the Congressional District Office to see what they do with it. But it's only because it has this bird on here. If it didn't do this, I would go get a hard copy. And we're going to try to get hard copies of the same stuff, but because I don't want to wait, I'm just going to try to put it in and see what happens. Okay. So here we go. So Title 10 is another one that is. By contrast, Title 42 isn't. It is comprised mainly of individually enacted federal statutes, such as the Public Health Service Act, the Social Security Act, that has been editorially compiled and organized into the title, but the title itself has not been enacted. The distinction is legally significant. Non-positive law titles are prima facie evidence of the law, but positive law titles constitute legal evidence in all federal and state courts. 1 U.S.C. 204. Having on one hand non-positive law titles as prima facie evidence of the law, and on the other hand positive law titles as legal evidence of the law, means that both types of titles contain statutory text that can be presented to the federal state courts as evidence of the wording of the law. The difference between prima facie legal is a matter of authoritativeness, and legal is much better than prima facie. Prima facie can be rebutted. Statutory text appearing in non-positive law titles may be rebutted by showing that the wording in the underlying statute is different. And how would you do that? Or how would they do it? Well, they go get a copy of the slip law, and if there's any wording different at all, then it's different. And so the one that you just quoted from a non-positive law title and tried to use in a court case or whatever it is, it doesn't have any standing. So one thing is, if anybody ever brings a claim against you, you should be asking, well, I need an authenticated version of that law, or I consider it a false statement. Something like that. Okay, importance of law, blah, 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 blah. We don't need any more of that. It's pretty much the gist of it right there. I mean, this is the whole process. If you want to read about it, you're welcome to. But who can, so let's say we get a law, then what do we do with it? Well, here's an example. U.S. Immigration and Customs Enforcement, ICE, is an American federal law enforcement agency. Well, it's an American. That's me. I'm a national. I'm an American. Under the United States Department of Homeland Security, responsible for identifying, investigating, dismantling vulnerabilities regarding the national borders, economic, transportation, infrastructure. They have two primary components: Homeland Security investigations and enforcement removal operations. HSI special agents investigate a range of issues that threaten the national security of the United States, such as human rights violations, human smuggling, art theft, human trafficking, drug trafficking, arms trafficking, transnational gangs, financial crimes including money laundering, and it just goes on and on with the things that they can do. Formerly known as ICE Office of Investigations, agents have a statutory authority to enforce the Immigration and Nationality Act, which is Title 8. Excellent. U.S. Customs, General Federal Crimes, Title 18, right? So they can enforce these. Okay, well, I'm going to go get a copy of something that I want to use. Maybe I'll give it to them and have them enforce it for me. Having to do with the Nationalization and Immigration Act, because I have evidence that the Secretary or the State Department is saying that I am not a citizen of the United States. Another one is the Office of Responsibility, reporting directly to the Attorney General, is responsible for investigating allegations of misconduct involving department attorneys that relate to the exercise of their authority to investigate, litigate, or provide legal advice, as well as allegations of misconduct by law enforcement personnel related to allegations of, right? So this, the only thing that these people, that this office of the Department of Justice investigates is misconduct of its attorneys. And if you watch my earlier videos over the last, I don't know, 4 months or so, I was trying to help a gal in Kenya who was the mortgage broker. You know, one of the dominoes in the mortgage meltdown, that when it tripped, they were going to be the fall guy. And sure enough, she went to prison for 5 years. Even though we tried the things we tried. But I had pointed out to the chief judge in a letter that I had wrote for Kenya that she sent out to the chief judge out in California that the government attorneys were not using the name that was on their license. And therefore they weren't complying with the law. Well, that happens to be 28 U.S.C. 530 B or D. I don't remember which one it is. About the conduct of an attorney. And we'll get to that in a minute. Right? And 28 U.S.C. is a positive law, so I could just provide her the text of the law. I don't need to go get a certified copy or authenticated copy. Right? According to what was stated earlier, based on what they say, if it's already positive law, then the text itself is legal evidence. So, somebody who can enforce the law, that's what I'm looking for. And this says these people can enforce this is Homeland Security now, don't jump out of your chairs, that they can enforce the Immigration and Nationality Act. And I want them to. Okay. All right. Okay. Bear with me just a second here. Okay, so here's that section of code. Ethical Standards for Attorneys, 28 U.S.C. Code, subsection 530B. Ethical Standards for Attorneys for the government. Now, I don't believe that the way they have it, 28 U.S.C. Code, I don't know if that's the proper way to do that. Right? What we need to do is figure out what is the legal citation that you need to put, and do it exactly the way the legal citation is. But what it does say is, an attorney for the government shall be subject to the state laws and rules and local federal court rules governing attorneys in each state where such attorney engages in that attorney's duties to the same extent and in the same manner as other attorneys in that state. Well, every attorney in your state has to be a member of the state bar, or I'm going to say this, they have to be licensed by the state to practice law. They have to go before like the Supreme Court or something. And they do an oath of office, and that oath of office has got a particular name on it, and basically they get commissioned as officers. They should have a commission as far as this goes. But whatever name they have on their license or their authorization or whatever you would call it is the name that they have to use. Right? If you don't use that name, well, then you're using a fictitious name. That's what I say. And I'm just trying to find somebody to say, hey, you can't use that name. So Robert Allen Rytlewski might be the name that's on the attorney's license. And if it is, I can't write on the paper and subscribe my name as Robert A. Rytlewski because it's not the same character. And that's what I'm basing this on. I'm going to say, well, you broke this ethical standards, right? Um, as used in this section, the term attorney for the government includes any attorney described in Section 77.2 of 77, Title 28, Code of Federal Regulations, which is its own good little part in this whole thing. Title 28, Code 28 CFR 77, I guess. And also includes any independent counsel or employee of the counsel appointed under Chapter 40. So, it includes more than just the people that you think. And so in Kanye's case, the U.S. attorney and the assistant U.S. attorney and whoever else is involved as an attorney, they're all using a name with a middle initial. But when you went to, because this was in California, to the state bar website in California, and the state of California says you're all going to be members of the bar, and you look at the name that's on the bar website, they have their middle name. But they're not writing it on paper. And I've done, numerous videos on this particular thing, and I have to chuckle because here just recently, the governor of Illinois came out and he said that the Illinois Supreme Court is part of a corrupt system. Of course, he is too. He didn't mention himself, but he certainly said the Supreme Court was. And when I think of all the paper that me and Rose sent to his office and to the ARDC and to the county and so forth, pointing out, hey, you guys aren't using the name that's on your license, and these people aren't using the forms that you say they're supposed to use, and so forth and so on, and they didn't do anything about it. Yeah, they are part of the corrupt system. So don't go to them, right? You got to find the other system. That's not the right Supreme Court. It's the lowercase Supreme Court. And as it turns out, the highest court there is a court of parliament. So said Lord Blackstone, so said Lord Coke. That's why we're looking at Congress. But back to this. So this 28 U.S.C., although I don't believe this is written properly, is positive law. So I should be able to the text itself is legal evidence. And I'm going to send this to this Office of Responsibility. I just haven't finished it up yet, right? To the U.S. Department of Justice, Office of Professional Responsibility, yada, yada, yada. And they have an email address. So I can just go email them a copy of the law and tell them it's positive law and, ask them to enforce it. But I'm going to include the other law, which is the False Statements Act. And I have that up here right now. Jeepers. Go back here real quick. If you were to Google, what is the name of this thing here? False Statements Accountability Act of 1996, or False Statements Accountability Act, and you just look at the sites that it's available from. You're going to find one that's from the GPO, Government Printing Office, and if you click on it, you'll end up with this, and this has got that same bird on it. So again, this is a certified copy of this public law. This is an authenticated copy of this public law. And this public law, Section 101 of Title 18, is amended to read as follows. Except as otherwise provided in this section, whoever, in any matter within the jurisdiction of the executive, legislative, or judicial branch of the government of the United States, knowingly or willfully, falsifies, conceals, or covers up by any trick, scheme, or device a material fact, right? So if you conceal a material fact, it's a false statement. In other words, silence can be seen as a false statement. Makes any material false, fictitious, fraudulent statement or representation, or makes or uses any false writing or document, knowing the same to contain any materially false, fictitious, or fraudulent statement or entry. All these are considered false statements. Well, every piece of paper that these attorneys put into this court case is a false statement because they're not doing it as an attorney. Every man's a liar. Right? They're not using the name that's on their license. And as it turns out, the CPAs, they don't use the name that's on their license, or they don't have a license, which means all the CAFR accounts have not been properly audited and are all susceptible to auditing now by the whoever does the auditing. I can't remember the general, whatever his office is. Yeah, somebody does that stuff. Right? Doctors don't use theirs. The psychiatrist that is going they want to use to have you be evaluated isn't going to use his. Whatever it is, nobody uses the name that's on their license. They're all false statements. And so here, this is what I would consider to be a slip law, being enacted by the Senate and House Representatives of the United States of America in Congress assembled. I don't know if it's supposed to be United States or United States of America. I have to go back and look at what the enacting clause is. But it does have the burden on it. I'm going to send it to them and say this is the law that they're breaking. Along with just putting the verbiage from 28 U.S.C. into the text and emailing it to the lady at where was she at? Office of Professional Responsibility. Department of Justice, and it's Robin C. Ashton. Yeah, Robin, she's using a middle initial too. And we'll find out. But she isn't working for the state. These other ones, they have to, because they're out in the state, they have to follow the state law, and they're not doing it. If they didn't register their fictitious name, they're using an unauthorized fictitious name. So what happened to me? If you were following my videos, I sent requests for assistance to my congressional office saying that there must be mistakes in my records, that my birth had never been properly registered in the state. And so my proper person was basically stateless. And I know a lot of people are running around getting their, I don't know a lot of people, however many did it. They went and got their, something to do with their birth documents authenticated. That's excellent, right? But what the fuck are you going to do with it? Put it back in your drawer where you got it from? No, it needs to go somewhere. That's part of where it needs to go. And it was supposed to have been registered with the state. But it never made it to the state. And I talked about this in detail in my last video. It never made it to the state. Now, when you go and you look at your state, who has custody of all the legal documents, it's your archivist. And so if you've already gone and had your birth documents authenticated, contact your archivist and say, hey, aren't you supposed to have a copy of my birth records? Here's an authenticated copy. Can you, how do we get the filing fixed? It wasn't properly filed. So your proper person isn't seen as being a national of the United States. You're just an undocumented worker. That and the fact that Social Security then, what they did is at the same time, because this all happens when you're born, somebody filed paperwork and put your property, your Social Security account in the name of somebody else. In my case, Robert A. Ritlewski. Middle initial got my account. He's seen as the one having the account. And so I pointed all these out, and I sent a thing, and I did everything they wanted you to do. You're supposed to fill out their disclosure form, and well, I got an answer back that was just like this as an email. You know, it's not on any kind of letterhead or nothing. Our office received a request for assistance and privacy release and contacted the relevant agencies. The U.S. Department of State reviewed your request and concerns and responded that United States passports are only issued to United States citizens. Individuals that are not citizens of the United States cannot obtain United States passport. In addition, the Social Security Administration provided the enclosed response regarding your concerns with your name as it appears on your Social Security card. We trust this information is helpful. This closes your inquiry with our office. Sincerely, Office of U.S. Representative Justin Amish, 3rd District of Michigan. Now, some places they just put 3RD. This is 3rd District of Michigan right now. It doesn't say Congressional District. I think when they use the 3, it's 3rd Congressional District. This is just the 3rd District of Michigan. But it's not been signed. It's not on official letterhead. And the State Department is saying that I'm not a U.S. citizen. And it only got worse because the Social Security said it was okay, you know, that there was really nothing wrong with the paperwork. I wish I hadn't done that. Okay, hang on a second. Okay, so on a passport, at least like mine, you got this page here, which is actually the first page of the book. This is the cover, passport book, right? This is the inside cover of the book. Here's the first page of the book, and it says, the Secretary of State of the United States of America hereby request all whom it may concern to permit the citizen/national of the United States here named herein to pass without delay or hindrance, and in case of need to give all lawful and aid and protection. Well, herein would mean from here in to the book, and from here in there's nobody listed. Now, maybe down here, it should have said Robert Allen Rytlewski. Maybe here where the space is, it should say Robert Allen Rytlewski, and then you would sign it. But there's nobody named herein. And then on my Social Security, this is the stub with the Social Security number. This is the bottom half of the stub, and on the back of that it says your name and Social Security number, account number appear on the other side. And you flip it over, it said Robert A. Rytlewski. Well, that ain't me. They put my account in somebody else's name. I'm sure the SS5 or whatever was used at the time is correct. It says Robert Allen Rytlewski. Yeah, maybe I'll show you what they said. But anyway, so that's the... Forgetting Social Security for a minute. This is what I was complaining about, and then my congressional district wrote back and said the State Department said, well, only citizens of the United States get passports as citizens of the United States. And that's where we're at today. So this is the Immigration Act, and because Title VIII isn't positive law, you can't just say Title VIII. But you can go get yourself a copy of the Act as a slip law or as part of the U.S. As part of the statutes at large. And in this law, there is a section 360 that says proceedings for declaration of United States nationality in the event of denial of rights and privileges as a national. I've just been denied. If any person who is within the United States, right? So within the United States, one of the definitions of the United States is the geographical boundaries of the United States, right, from sea to shiny sea. Well, I'm within. Claims a right or privilege as a national, and I do, and is denied such right or privilege, which I am, by any department or independent agency or official thereof, upon the ground that he is not a national of the United States, such person may institute an action under the provisions of Section 2201 of Title 28 United States Code against the head of such department. Okay, says I can. But also, as it turns out, it says that, Homeland Security, basically, they can enforce this act. So I could say, well, either I go back to my congressman, which I probably will, but I might send it to Homeland Security also and say, according to you guys, you can enforce the Immigration Act, and this section here, 360, I need to have enforced. Here's a certified or an authenticated copy from the Archivist, because according to somebody who sent me this false statement, claiming to be the 3rd District of Michigan, they said they talked to the Department of State, and they won't give me one. They say I'm not a citizen of the United States. Something like that. And so, anyways, it allows you to bring a claim according to 28 United States Code 2201, which says creation of a remedy. In case of an actual controversy within its jurisdiction, except with respect to federal taxes over other than actions brought, except for some federal taxes or some other kind of proceedings involving anti-dumping and merchandise. Sounds like commerce stuff. In any court of the United States, upon the filing of an appropriate pleading, may declare the rights and other legal relations of any interested party seeking such declaration, whether or not further relief is or could be sought. Any such declaration shall have the force and effect of final judgment or decree and shall be reviewable as such. Well, how do you use this 28 U.S.C. to get your property back? 28 U.S.C. 2201, creation of remedy. Right? You could, because the thing is, it has to be an appropriate pleading. And so you need to have it addressed to the proper court. And the proper court has "for the" in the name, or at least it appears it does. If you look online at your local federal court, the district court, the United States District Court for the Western District of Michigan is what it should say, and it will say United States District Court, Western District of Michigan. But we may be looking for the district courts of the United States, which are actually more like something to do with your township up through your congressional district, because that's a district of the federal government, right? Because now we're talking about the different republics, the 4 levels of republics that were established by, or at least envisioned, I'll put it that way, envisioned by Thomas Jefferson. The national, the state, the county, and the local. And everybody was a member of their local, and at the local level you voted directly for everything. And one of the things you voted for was who from your local would represent you at the county. And then all these counties would get together and they'd have their electors that were elected from now we're talking the delegates, to that level, and they would vote on who would represent the county at the state. And the state would represent who would represent them at the national level. And it was one House of Congress. Didn't have a bicameral level. It was how the Continental Congress was set up. Okay, 28 U.S.C. 2201. So here's the law. I'm believing I would have to get. Notice this doesn't have that bird on there. So I got to either need to get it with the bird and be able to send it by email, or I need to get a hard copy with the seal and send it by regular mail. And right, this one has the bird on it. Public Law 104-292. This is Public Law 414. All right, it's like they did it different. They got different ways of doing the public law numbers for some reason. This one is in the statute at large, 110 Stat 3459. Again, that's the False Claims Act. And this, I don't see where, 66 Stat something or other. What's the rest of it? Why do they got this freaking bar at the end and not one at the beginning? Why do they do things the way they do? I just don't understand. But I do understand the idea of having a proper seal on paperwork. Okay, and then where? Well, that's my plan on answering to the next level for what I have going with my congressional district. So, okay, I need to load a more piece of paper. Hang on. Okay, we're just about done. However, go back to National Archives Record Administration just one more time. Make sure we're highlighting the things that need to be highlighted, because there are lots of little pieces that roll all over the place, and I'm not really trying to do anything except pass on information. I'm not saying go do anything to try it any particular way. I'm saying, hey, maybe you know something more about this, because Bobby talked to Patrick out in Arizona, and Patrick said he knew a guy or heard of a guy or something. You know how this stuff is, and so there's probably a lot of truth to the story. We just don't have the details. But he was in court bringing up all sorts of laws. Why it should be this way or shouldn't be that way or whatever. And so the judge said to the guy, well, if you get me that law under seal, I'll consider it. And so he did. And, the case went away. But I don't know what that means. I don't know if it was dismissed or what the situation was. But, right, the judge said, well, if you get me those laws under seal, I'll consider them. Right? You need to make it foolproof evidence. We never, this much I know, we never put evidence into court cases, because we're not going to the exhibit clerk to give her our exhibits. If you don't go to the exhibit clerk, it didn't get put in the court case. And if you're going to give them an exhibit to put into the court, and and so again, these are things I did videos on where people have went and asked those questions. They said, yeah, you need to give it to the exhibit clerk for the judge to see it. Right? So if you had a court case and you were going to take them an exhibit, well, take them the highest form of evidence you can, and that's something that comes from a slip law. National Archives, Record of Administration, valid in all courts, in all tribunals, in all agencies, federal, state, period. Official publication of the law is admissible as legal evidence. 1 U.S.C. 113. Remember that. The OFR, Office of Federal Register, assigns a permanent law number and legal statutory citation of each law, prepares marginal notes, blah, 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 blah. So what do we need? I believe we need to know what the permanent law number is and the legal statutory citation. How do I need to put it on a piece of paper to reference it and then provide them a copy? Electronic documents, I've already been showing you those. Those are the ones that got the little eagle on it. To me, it looks like, okay, it's been the OFR publishes the slip laws through the Congressional Printing Office. Slip laws may be attained by, and if you go look at these things, they got that eagle on there. I think they're okay. Statutes at large is about the same, just different. Now that's 1 U.S.C. 112. Title 1 is a positive law. And since this is, what I'm reading to you here is off of the National Archives website, if they put 1 U.S.C.112, I got to believe that that's the proper way to do it. It also contains concurrent resolutions, reorganizations, all sorts of stuff, right? Do the same thing. But the National Archives Record Administration is an independent agency of the United States government charged with preserving and documenting government and historical records and with increasing public access to those documents which comprises the National Archives. NARA is officially responsible for maintaining and publishing the legally authentic and authoritative copies of acts of Congress, presidential proclamations, executive orders, and federal regulations. If you get any, those are all considered federal law. If you get any of those that work to your favor under the seal of the proper seal from NARA, which, because they got 3 different seals, and just real quick, take a look at that. National Archives and Record Administration, 1985. That's a seal. National Archive of the United States. Right? Everything's the same except the words are different. That's a seal. National Archives Trust Fund Board, 1941. That's a seal. They got these 3 different seals used for different things, and I haven't really had a chance to study this part yet, but it seems to me, if we're not talking archives, we're talking, like working copy, legal documents. I just believe it's this one. I would have said it was the yellow one yesterday. This one here from 1934, National Archives of the United States. National Archives and Records Administration. This is like the Secretary of State's office. Right? We need to have things administered, not historical documents so much. I'm guessing. I'm going to ask them. I'm going to say, when you give it to me, I want it to be in compliance with 1 U.S.C. 113. As long as it is, I'm going to take their word for it. Okay, but see, they are officially responsible for maintaining and publishing, right? If you want to get a copy of the law, by God, you got to go to them, of the authoritative copies. Not just a piece of paper printed, no, the authoritative copy of acts of Congress, presidential proclamations, executive orders, and federal regulations, all of which you could use to your benefit if you had an authoritative copy. The NARA also transmits votes of the Electoral College to the Congress. Right? So they're acting like the Secretary of State in your state who handles at least some part of the election law. The chief administrator of the NARA is the Archivist of the United States. The Archivist not only maintains the official documentation of the passage of amendments to the U.S. Constitution by state legislature, but has the authority to declare when the constitutional threshold for passage has been reached, and therefore when an act has become an amendment. Ask them. Right? If you don't believe the 14th Amendment is in play, ask the Archivist. He can tell you. The Office of Federal Register publishes the Federal Register, Code of Federal Regulations, the United States statutes at large. Among others, it also administers the Electoral College. Right? So, this is an office that's within, it's an office of the United States government within the National Archives Record Administration. And it has its own guy that's its own officer. So I don't really know the hierarchy of all this. I just know that it's where you go to get the official copies of laws, and they have something to do with elections. The office publishes, it also examines Electoral College and constitutional amendment ratification documents for facial legal sufficiency and authenticating signatures. And so you can get to the Electoral College's website through them, but you can find the website for the Electoral College, and it will show you the documents that were provided them by law in a particular method. It's all kind of spelled out on their website. That's going to be another video itself. But these documents are supposed to be certified, and which means that there should be a witness statement on it someplace. And on Michigan's, there isn't anywhere. It's like, well, that isn't right. So, I mean, just one more thing I've added to my list. If I got to send a complaint to them about Michigan stuff, I'm having to take a better look at it. That's what they're supposed to do. Examine Electoral College and constitutional amendment ratification. Well, let's find out what's been ratified. Independent agencies in the United States federal government are those agencies that exist outside of the federal executive departments, those headed by, so they're not under cabinet secretaries. More specifically, the term may be used to describe agencies that, while constitutionally part of the executive branch, are independent of presidential control, usually because the presidential power to dismiss the agency head or member is limited. Congress established National Archives, right? This is how come the Court of Parliament is so powerful, because they enact laws and they change laws. So Congress, by an act, right, enacted and established the National Archives to preserve and care for the records of the U.S. government. The United States statutes at large, commonly referred to as the statutes at large, right? So the correct name is United States statutes at large, abbreviated SDAT, is the official record of the acts of Congress and concurrent resolutions passed by the United States Congress. Each act and resolution of Congress is called a slip law, right? So each act and resolution of Congress is called a slip law. What's a slip law? Just one act. A bunch of slip laws are put together. They become a statute at large. Statute at large gets codified into the United States Code. But if it isn't made into positive law, then it's just there editorially. And if you want to get a copy to use in court, you need to go back to the slip law or to the statute at large. And so those are two different levels. You got statute at large, which is the bound copy, and the slip law, which is the singular copy. And those are the two that we want to deal with in that area right there. At the end of the congressional session, slip laws, now commonly called session laws, are compiled into statutes at large, which are numbered and organized by Congress session. They are part of a three-part model for publication of federal statutes consisting of slip laws, session laws, being the statutes at large, and codification into the United States Code. 1, 2, 3. But they all started out as slip laws. It's just that once the code becomes, once the title itself becomes the statute, they don't necessarily update those acts, and you have to quote the statute. The idea is you're trying to enforce a statute, and the statute in a non-positive law title is each individual act. In a positive law title, such as Title I, it is, the whole title is just one act. You can throw the book at them, Dano. Codification, provisions of public law that contains only enacting clauses, effective dates, similar matter are not generally codified. Provisions of a public law that contain only enacting clauses, right? Well, that's what we kind of need. Effective dates and similar matters are not generally codified. So, let's start at the beginning. Codification. Today, large portions of slip laws, denominated as public laws, which is like the False Claims Act, or False Statements Act, are now drafted as amendments to the United States Code. Once enacted into law, an act will be published in the statute at large and will add to, modify, delete some part of the United States Code. So it's going to go into the code once it's been enacted as a law. Provisions of public law that contain only enacting clauses, effective dates, similar matters are not generally codified. Private laws are also not generally codified. Okay, so they're not going to put into this United States Code the part that has the enacting clause that says Congress enacted the statute, which is why you can't use this U.S. Code unless it's the positive law sections. Some portions of the United States Code have been enacted as positive law, and other portions have not been so enacted. In case of conflict between the text of a statute at large and the text of the provision of the United States Code that has not been enacted as positive law, the text of the statute at large takes precedence. And the text of the statute at large is going to have the enacting code in it. So they're not going to change the words, they're just not going to put all the words in, and because they don't match, and you're trying to use a code that's non-positive law, which looks like it's prima facie evidence, it isn't. It's going to be rebutted by somebody saying, well, it doesn't read the way that the law reads, because the law's got the enacting code on it in the statutes at large, and it doesn't necessarily have it in the United States Code. I hope that wasn't too confusing. Now, history. A little history. Public Law 80-278, which is 61-633, was enacted July 30th, 1947. I still haven't found that act. And directed the Secretary of State to compile, edit, and publish the statutes at large. But the Archivist does that now. 821 enacted and directed the Administrator of General Services to compile, edit, and publish the statutes at large. But the Archivist does that now. Since 1985, the statutes at large have been prepared and published by the Office of Federal Regulations of the National Archives and Records Administration. That's where we are today, and this is where we started out. But if this is this public law been so does that mean that this public law 87-278 and 81-821 have they been superseded, or are we talking about the same person? Right? General Services has an administrator, but is that the same as an administrator of General Services? I don't think so. Right? This is who's over General Services and over everything else, and then General Services has somebody who administrates it from within. This is from without, the administrator of. It just seems to me, it's like, okay, at the end of the day, the National Archivist now is also considered the administrator of the General Services and the Secretary of State, because he's the one who's doing this now, unless these other sections have been repealed. Until 1948, all treaties and international agreements approved by the United States Senate were also published in the set, but these are now appear in publication entitled United States Treaties and Other International Agreements, abbreviated U.S.T. So up until 1948, and when was the Warwick Peace Pact passed? That wasn't called the Warwick Peace Pact, it had a different name. 1935, so it should be in the statutes at large from 1935. In addition, the statutes at large include the text of the Declaration of Independence, Articles of Confederation, the Constitution, amendments to the Constitution, treaties, so forth and so on. In the Articles of Confederation, there's a Congress of one level. There's not senators and U.S. representatives. There's just delegates. And yet we still have that. We got the Declaration of Independence, and we got the Constitution. And when you read about the Continental Congress, they had met. The third time they met was to amend the Articles of Confederation, which is not what they did. They went and wrote the Constitution. And so the Continental Congress was never I don't know what you say. They just quit meeting. What do you call that? Sendai. They shut her down. Sendai until they meet again. And if all the delegates for the different states got together, they would make the Continental Congress. And how you get that word out, I don't really know yet. Sometimes a very large or long act of Congress are published as their own volume of the statute at large. For example, Internal Revenue Code of 1954 was published as volume 68A of the statutes at large. 68A Stat 3. Now they call that code the Code of 1986. Talked about it earlier. Okay, and that's the way the things are supposed to be. How to cite Constitution, statutes, and similar materials. Right? But just real quick to go back to one other thing here. We talked about Declaration of Independence, Articles of Confederation, Constitution, amendments to the Constitution. Okay, how about the Declaration of Independence? Getting a copy of it under the seal and claiming that, because that's the one that guarantees your right to life, liberty, and pursuit of happiness. And it's supposed to be protected by the Constitution. Right? It didn't come from the Constitution. The Constitution was created to protect those rights. And so you want to claim your God-given unalienable rights of the Declaration of Independence, which is a living document because it was sworn to God. Okay, I'm about done. I hope I didn't confuse you guys too much, but I just wanted to show you real quick. Right, statute citations, most common form, 42 U.S.C. / 405 C2C. Why don't you put the whole thing? Or, nail it right down drill it right down to the point you're trying to make. (42 U.S.C. 405 C2C 22). Yep, same one. But then it talks about having a date element and so forth and so on. So I got to spend a little more time. But if somebody already knows this and you want to send me an email to courtofrecord@aol.com and you're absolutely positive you know the legal citation, excellent. Well, then, send it to me. How you do a legal citation. And I'll do a video on it. Make sure we're all doing it right. But again, what we want to make sure we're starting with is self-authenticating evidence, probably under this seal or similar, like this, with this on there, this electronic version, saying that this is the most latest. This is the latest version, right? And one thing I talked about here is official seal. Means the originals of the seal showing the exact form and content. Replica means a copy of an official seal or an arrow logo display for displaying the former content. 3 official seals are illustrated, 1, 2, and 30. The description of each seal is as follows. The National Archives Record Administration seal. The design is illustrated below in Figure 1 and described as follows. The seal is centered on a disc with double-lined border. The words National Archives and Records Administration encircled inside the seal and the date 1985 at the bottom. Solid line rendition of a heraldic eagle displayed holding blah, 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 blah. Okay, above the other. And there it is. That's the one it is. So what do they use this seal for? And it's in here. I got to read this stuff closer, but it talks about what each of these seals are used for, and I just don't have time to read it yet. So, okay, I'm done, and I'll regroup and do another one here when I get these other little tidbits put together. But next, I want to see if I send something, do they actually recognize it as being certified by the superintendent of documents, and see what they do with it. Alrighty, we'll see y'all. If you can, please do donate.